Still getting people. Good. Good afternoon, friends, and thank you for joining us today. We are thrilled to welcome the esteemed Professor Akhil Amar to our chapter. Our topic is the Constitution, Originalism, and the Presidency. With less than 2 weeks until Election Day, what a great time to discuss such important issues. There is perhaps no better scholar and legal mind to address these items than Professor Akhil Amar. His outstanding work truly speaks for itself, and it is a real honor to host him. Akhil Amar is the Sterling Professor of Law and Political Science at Yale University, where he teaches constitutional law in both Yale College and Yale Law School. After graduating from Yale College summa cum laude in 1980 and from Yale Law School in 1984, and clerking for Judge, later Justice Stephen Breyer, Amar joined the Yale faculty in 1985 at the age of just 26 years old. He is Yale's only living professor to have won the university's unofficial Triple Crown: the Sterling Chair for Scholarship, the Devane Medal for Teaching, and the Lamar Award for Alumni Service. Amar's work has won awards from both the American Bar Association and the Federalist Society, and he has been cited by the Supreme Court justices across the spectrum in more than 4 dozen cases, tops among non-emeritus scholars. He regularly testifies before Congress at the invitation of both parties, and in surveys of judicial citations and scholarly citations, he typically ranks among America's 5 most cited mid-career legal scholars. He is a member of the American Academy of Arts and Sciences and has written widely for popular publications, including the New York Times, the Washington Post, the Wall Street Journal, Time, and the Atlantic. He is an informal consultant to the popular TV show The West Wing. And his scholarship has been showcased on many broadcasts, including the Colbert Report, Morning Joe, AC 360, 11th Hour, Brian Williams, Fox News at Night with Shannon Bream, Fareed Zechariah, GPS, Aaron Burnett Out Front, U.S. Constitution with Peter Sagal. He is the author of more than 100 law review articles, as I'm sure many of you will be down the line, and several books, most notably The Bill of Rights, America's Constitution, America's Unwritten Constitution, and the Constitution Today. His latest and most ambitious book, which I'm thrilled that he's so generously given to all of us, is The Words That Made Us, America's Constitutional Conversation, that came out in May 2021. He has recently launched a weekly podcast that I can personally say is great, America's Constitution. A wide assortment of his articles and op-eds and video links to many of his public lectures may be found at akhilamar.com. As I said, and as you can tell from his bio, his work truly speaks for itself, and I hope you all brought tough questions for him. Please give Professor Amar a warm welcome.
It's so nice to be here with my friend Brad in attendance. I'm a big admirer of his work. We didn't know each other so well until recently, and I've become quite a fan of his. He's been on our podcast, actually, I think a double episode. Have you listened to this week's episode?
Oh my God, I failed the test here, folks.
This week's episode, I think it just launched yesterday morning. It's weekly. It's our 199th episode. We get every week except one. And this one is a bit of a retrospective. We talk about what we've done over the last several years. We're approaching our 4th anniversary, and we talk about all the amazing guests we've had on the podcast from all sorts of parts of life. People in the judiciary. Steve Breyer's coming on very soon. In the press, Bob Woodward has been on multiple times. Former senators, my former co-author, Gary Hart, and people, as I said, in the judicial branch and from the executive branch, but also great scholars. I think you're mentioned by name in this week's episode. So it's an honor to have Brad here. I'm so grateful to you all for coming. About an hour ago, 2 hours ago, I was able to say hi to our daughter, who is we have 2 and a son, but one of our daughters is a Georgetown graduate undergrad. And she lives in this town, and so that was very special. So thank you so much for inviting me to a school that's close to my heart, a place to which I've sent many large checks, tuition checks, and we think we got our money's worth. So this is going to be very interactive. I'm going to say 2 or 3 things, and then I want you to have at me with hard questions. So we build this as an event about the Constitution, originalism, and the presidency. Now, what are the connections between those? So if you're an originalist, you think about the Constitution as it was originally understood. You're interested in the origin of the Constitution. The father of the Constitution is, of course,
George Washington.
This is a trick question. You all were taught by Mrs. McGillicuddy in 8th grade that it was James Madison. Not at all. You can confirm the correctness of what I just said in about 3 minutes now, because you can go onto websites, America's historical newspapers, for example, and their word search. We'll just put in "Father of the Constitution." You will never find a reference to James Madison as the father of the Constitution until the 1820s, mid-1820s. Everyone at the time understands he's not the father of the Constitution. Okay, who is? Well, are we meeting in Madison, D.C.? When you look up, you see the Madison Monument, okay? Of course not. The Constitution, the father of the Constitution is George Washington. And I've just told you something important from an originalist point of view. The Constitution was designed by Washington and for Washington. And you'll miss this if you don't do originalism the right way. Okay? I am not a fan, truthfully, of Antonin Scalia's, even though I know he has a connection to this university. But he thinks originalism, he thought it was some sort of dictionary game, because he was into dictionaries, he was into words. But that's not actually original. That's not how John Marshall, for example, did it. Okay? So here's my take on originalism. It's understanding the Constitution as a whole, as it was originally understood. That's a history game. It's not a dictionary game. And the way you're going to need to play that game is to understand the whole thing, not an individual word or clause, the way Scalia did. That's what he was into, his words and clauses. You need to understand the whole thing in its historical context. So this week's episode is about understanding as a thing, not a clause, but the document as a whole, and you're going to need scholarship that helps you do that. This is part of this book is the first of a 3-volume series about the constitutional experience over 250 years as a whole. This is volume 1, 1760 to 1840. I just finished volume 2. It's called Born Equal, America's Constitutional Conversation, 1840 to 1920. This is the Fellowship of the Ring, the Two Towers. Volume 3 will give you the modification. So that's the Constitution as a whole over time. America's constitutional biography is the whole textually. And I walk you, the reader, through the text from start to finish. The preamble, Article 1, Article 2, and so on, and then through the amendments, which are chronologically laid out. And so that's actually a story that takes you through the centuries. Now, back to who the father of the Constitution is. If you understand the thing holistically and historically, you're going to compare the Constitution, not to a dictionary, but to the Articles of Confederation. And you're going to compare it to state constitutions, which were the antecedent documents. And when the dean walked into Brad's office to say hi to him, I mean, we're old friends from college and law school, we talked very briefly about some of his scholarship, which shows that judicial review was an established practice way before Marbury versus Madison, even before the ratification of the Constitution, even before the Federalist Number 78, which was part of the ratification of the Constitution, because state courts under state constitutions were already invalidating state statutes. Okay, that's judicial review. And Bill Traynor is one of the world's experts on that. So you're going to need, because he's actually doing more of an originalist analysis, comparing, looking at the Constitution historically, not through the lens of a dictionary. And that's how John Marshall did it. And that's how Abe Lincoln did it. And that's how actually Hugo Black did it. He wasn't just looking at dictionaries, he was understanding history. That's the tradition that I am inviting you to join. It's the tradition in which I'm a part. And when you do that, you will see that most of the stuff in the Constitution isn't particularly new. It's just a version of the state constitutions. It's a generic state constitution. States have written constitutions after the Revolution. In all the states except Connecticut and Rhode Island. So 11 new state constitutions beginning in 1776. Some have actually they're already on version 2.0. And they are written documents. Actually in Massachusetts and later New Hampshire, documents adopted by some special popular mechanism. And they're tripartite. They all have three branches, legislative, executive, judicial. Outside of Pennsylvania and Georgia, they're all bicameral legislative. So many of them have bills of rights, which is why the first thing ordinary people say when the Constitution's draft is made public for ratification, where are the rights? Dudes, you forgot the rights. There's no Bill of Rights. Because state constitutions have bills of rights. So now when you're doing true originalist analysis, you're comparing the Constitution to its predecessor documents, there are only two big new things, truthfully. A hugely powerful federal government, way more powerful than the Articles of Confederation, and a massively powerful federal executive. That's the new thing when you compare it to state constitutions. Only one state gives its chief executive a veto pen. Only Massachusetts. In New York, the governor shares a veto pen with the council, and if you go to Brad's office, you'll actually see a picture, a cartoon of a later New York governor, Charles Evans Hughes, who actually understands that originally his predecessors had shared a veto with the Council of Revision, which turns out to be really important in a case called Home versus Smiley, which turns out to be really important in the modern case of Moore versus Harper, an independent state legislature doctrine. And John Roberts, I was at the oral argument, that was the first thing he asked, was about basically, because he's going to pay attention to Charles Evans Hughes, because he's going to pay attention to former Chief Justices, because that's how Chief Justices think. Back to what I said before, only one governor has a veto pen, and now you're giving it to the president. No governor has the following package: veto pen, pardon pen, 4-year continual re-eligibility, independent election, control over the military. Wow. I just told you who the Constitution actually is by and for. For our first president, George Washington. Everyone knows it's going to be Washington. Everyone knows that. It's designed by him, for him. He's the unanimously elected presiding officer of the Philadelphia Convention, and he's so influential he doesn't even have to open his mouth, and he doesn't when you read Madison's notes, but you have to read them, with historical sensitivity. So Washington never says anything because he doesn't have to, because he smiles and people vote yes, and he frowns and people vote no, and you can walk across the street, so to speak, to the National Archives, and you can still see a smudge in the parchment because it's already been prepared on the last day, and they're about to vote on it, and he says, gee, I think maybe we made a mistake in the size of Congress. I know it's really late, but could we change 40,000 to 30,000? And this is highly irregular. But everyone says, whatever you say. And they erase the thing, and you can see the smudge in the parchment. That's how powerful George Washington is. There are only 55 people in Philadelphia. He's one of them. Okay? And he's the unanimously elected presiding officer. And he's there every day. And the 54 other people, 39, including him, end up signing it, one by proxy. 5 of the people in the room are basically his law clerks, meaning his aides de camp, from the American Revolutionary War. Half of them fought in the American Revolutionary War, many of them in the Continental Army, which is the only national institution, not continental institution. But from 5 different states, he's got his little law clerk. From New York, his name is Alexander Hamilton. And in Virginia, it's Edmund Randolph. And in South Carolina, it's Charles Cotesworth Pinckney. And there's a guy named Mifflin from Pennsylvania. And there's this guy named McHenry. They're going to name a fort after him in Maryland. So that's influence. James Madison, give me a break. The guy is 5'4". And I know what I'm talking about short people, really. No one pays any, no one's heard of him. George Washington and Ben Franklin are the only 2 people that ordinary Americans have heard of. Ben Franklin, because he's a world-famous scientist, the man who brings lightning from the sky. He's the American Prometheus, who tames, lightning. If he were alive in the 20th century, he'd be Albert Einstein. Okay, he's world-famous, but he's old. And George Washington, because he had the only army on the continent, he gave it up. And he could have made himself king, emperor, czar, and didn't. And that's the story told in one of the 4 amazing paintings just across the street, so to speak, in the Capitol Rotunda, when you see these great trumbuls, and it's George Washington handing over power, not trying to make himself a dictator or king. And very shortly thereafter, see, this had never happened before. Caesar has an army and makes himself, in effect, a supreme leader. And so does Darius, Darius, Xerxes. Cromwell's going to name himself Lord Protector. Very soon thereafter, Napoleon will grab the crown from the hands of the Pope and put it on his own head and make himself not just king, but emperor. Okay? And Washington steps away. He's the greatest man in America, and every American knows that, and the Constitution is designed by him, for him. Now, why does that matter? Okay, that's what the Constitution is actually about, strong executive power. Maybe too strong. You have to be very careful, my friends, whom you pick as your president, because the president has so much power. Very careful indeed. Okay, so I just told you something kind of important. And it's a national security document, which means it is about borders. It totally is. And James Madison is not up there on Mount Rushmore, because when he's president, he lets the Capitol burn to the ground, and that's not a good look. Because he doesn't understand, actually, the nature of executive power in a way that George Washington does. But George Washington, as president, walks away from power yet again. Okay, it was designed for someone like that, who couldn't even be re-elected, but who chooses to put country first, above all. They call that virtue. So, now, I just told you something important about how you should think about the current election. And I said, national security is important and borders are important. They are, but so is the character of this person, not just the policies, but the person, because it's such a powerful office, and it's maybe the Achilles heel in our system. No state has anything like that. The states changed their governorship to now align with the new presidency. So now every state governor has a veto pen. That only one in 1787. Every state has a 4-year term, except for New Hampshire and Vermont, which are 2-year terms. Our governorships have been reinvented over the years in the model of the American presidency, you see. But at the gubernatorial level, you've got independent attorneys general. They're often picked independently. You don't have a strong unitary executive. You have an independent secretary of state or secretary of elections. And so they don't control nuclear forces, and so even your strong governors are not remotely akin to today's presidency. Okay, so I told you a little bit about the presidency, a little bit about the Constitution, told you a little bit about originalism. So I think I've said now enough to have fulfilled my contract, carbolic smoke ball or something, and I promised for the rest of the event that we just have a conversation. You ask me questions about anything I just said or anything about originalism, Constitution, the presidency, or even anything about the Constitution more broadly, and I'll do my best to answer. Please.
Is there any indication from the convention debates or anything sort of that era of these concepts of, I guess, they're sort of related, executive privilege and like presidential immunity? Because they seem to have been kind of made up.
It's pulled out of John Roberts' ass. So that's what I said in my podcast. And we only have a little time, so I'm often going to say, listen to the podcast. It's free. Those of you who are going to take the bar soon, you can get CLE credit just for listening to the podcast. And it's free and it's weekly. And I'm so disheartened because I admire John Roberts, and I think he was genuinely admirable when he was not a partisan in the Obamacare case. He's the only Republican in this town who actually voted for Obamacare, and good for him. And I held him up as a role model, and he clerked for, among other people, Henry Friendly, who in my view was the greatest judge of the 20th century, and Brad has written about Henry Friendly, and Friendly clerked for Brandeis, and Brad has written about Brandeis, and I thought, here's John Roberts in principled tradition, that there is this idea of law, and it's not completely partisan, and it travels through great jurists like Louis Brandeis and Henry Friendly. John Roberts is part of that. And yes, it's a Harvard tradition, but there are other good schools. They're not just two good schools, Yale and Georgetown. Turns out they're a handful. And so, I'm rooting for my country. I'm rooting for John Roberts. And I did not like Shelby County at all. And he wrote that. And I was apoplectic about Bernie, because I saw that as the first step toward the invalidation of Sumner's voting of the Voting Rights Act. I saw that then. That's what I actually cared about. Because Brad and I talked about the city of Bernie. He recently, I guess, had a class in which he presented sort of my ideas as a critique of my friend Anthony Kennedy's in city of Bernie. Because I saw that day that was the first step. He's into sports, and he's written about basketball and football. Give the other person the first step you've often lost. Okay, that first step in basketball or football, and so Bernie was the first step. I said we have to stop there. So Shelby County was a bad decision. It's one of the three worst of my lifetime. The Bush versus Gore was a disgraceful decision. But I thought, okay, Shelby County, that was maybe a one-off or something. This was the worst case of my lifetime, this Trump immunity case, because they just made it all up. And you said what? Look, elephants don't hide in mouse holes. If there really were immunity for criminal misconduct by the President of the United States, it's a very powerful thing, don't you think they would have said it in the text and people would have talked about it? Or they would have defended it in the ratification process, the year-long process. I can't prove the negative, but it doesn't say this in the text. The text isn't just what it says, but what it doesn't say. I can't prove that no one ever said ex-presidents are immune, but they pointed to not a single person. So I just told you text, just told you history, structure, no man is above the law. They say that again and again and again. This is our big theme. Hamilton says all this about the presidency. So does James Wilson. And now let me tell you what the text actually does say, because I wrote a little piece. It's in the Atlantic. You could read it in 5 minutes. I went on MSNBC, and here's the meme. I said, they just made the Constitution itself unconstitutional. I'll prove that in 2 minutes, because this is what you can do when you know how to do constitutional law, and I know how to do it. And you can too if you read the damn books. You can. It's not rocket science. My brother, I have 2 brothers. One is a literal brain surgeon, okay? That's hard stuff, okay? He writes a book. I'll never be able to understand a sentence of it or a paragraph. And after I read the book, I can't perform brain surgery, okay? You read my books, you will know more than I knew before I wrote the books. You will, because it's not rocket science or brain surgery. You will know maybe more than half of what I know. Now, not everything that I know is in the books. Brad and I talked about how that you always often, if you're writing a good book, you know more than you're able to put on the page. There's your backstory and all the rest. But common law actually is not that hard. It's designed for ordinary people. Ordinary people ratify the thing. So I'm now going to prove that. So I disproved by negative. I said, it doesn't say that in the text, and I made not a single textual argument. I know no history to support it, and they cited not a single bit of history that's actually relevant, as opposed to at a very high level of generality. The structure of the thing is that no man is above the law, rule of law, that's what it's all about, and that's who George Washington was all about. Now I'll prove it to you a different way. The Constitution actually says when you pull it out of your pocket and you look at it, it actually talks about how presidents are impeachable. And you see kings of England worked. Oh, that's another. So your basic baselines, if you look at the Constitution, if you're religious, compared to England, compared to the Articles of Confederation, compared to state constitutions, those are going to be your basic baselines. Okay? Maybe classical antiquity, they do call it the Senate. You can't be in this town without really being impressed by the appeals to, this place was supposed to be the new Rome, and they call it the Tiber River or something. It's like some creek or something. But they are trying to create a republic on a classical model. So maybe you could look at ancient Rome or ancient Greece as well, but especially look at what they would have known. State constitutions, Articles of Confederation, and the English tradition. So in England, you can't impeach the king. That's why you have to kill him, and Charles I, they cut his head off, okay? So what does it say about impeachment? Because to repeat, you can't impeach the monarch in Britain, but you can in the United States. And at the end of Article 2, they say, the president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. They say the president can be impeached for bribery. Now, presumably, that's bribery pretty obviously, not solely, but paradigmatically, bribery in connection with his powers. He was bribed to veto a bill, to pardon someone, to appoint someone, to remove someone, although the removal power is not as expressed, but that's what it's about, obviously, bribery in connection with his official behavior. And then it actually says, you can be impeached for that, and it says the Senate tries all impeachments, and then it says, judgment in cases of impeachment shall not extend further to removal from office and disqualification to hold or enjoy any other office of honor, trust, or profit in the United States. So we're not going to cut your head off. But, the party convicted shall nonetheless be liable and subject to indictment, trial, judgment, and punishment according to law. So they're saying you can be impeached for bribery in connection with an official act. And once you're convicted, you can be tossed out of office and actually disqualified from future office. But, of course, you're subject to ordinary criminal prosecution. And you say, They say, but unless you're impeached, somehow you can't be. No, this was one example because they were worried about a certain kind of double jeopardy called ultra fraud convict. But of course you're subject to criminal prosecution. Generally, that's the backdrop assumption. And I promise you the Federalist Papers say just that. Wow, it's disgraceful. It's the worst opinion of my lifetime. Probably worse than Bush versus Gore, because that was a hurry-up offense. Maybe worse than Shelby County, because, I don't know, that was a bad one, but because this, okay, here's why it's worse, because it seems so frickin' partisan and stinky and stupid. And I'm going to have a very difficult time looking my students in the eye and telling them to take seriously the Supreme Court as real judges. Oh, and here's why it's worse, because they've been talking about originalism, okay? And they weren't talking about that before. So I'm going to be brutally honest with you. I'm going to lose half of you, but at least I'm honest. If judging is just their judgment, their policy views, well, then they're the experts. If an oath is just, I swear an oath to my integrity, to my fidelity, to public service, to my good faith, well, then it could be whatever you want. But no, God damn it, you took an oath to the Constitution, and it's a thing. It's a text. Okay? And if you're going to take seriously that, and you're going to call yourself an originalist, oh, if you're going to do that, then here's the New Yorker map of the world. There's God. Under God, there's the Constitution. Under that, there's Akhil. 8 frickin' books that are just about that. They're not my policy views. And you haven't read 8 books. You're writing books about your wonderful life or, your autobiography. No, goddamn it. That's what you can do if you're just a legal realist and it's about your judgment. But if you're a serious originalist, oh, there's an external metric. And it's what the Constitution really does say from the point of view of history and structure. And God will judge us all. But in the meantime, I'm going to judge you on my podcast. And if I'm a crackpot, then when I die, and it's not that far, off in the future, these books won't live. I have every incentive to actually tell you what it really says, so that in 50 years or 100 years, you say, well, there are the Federalist Papers, there's Joseph Story's commentaries, there are these serious books that aren't about what Akhil personally believes. Akhil doesn't like guns very much, but there is a Second Amendment and a 14th Amendment. Akhil doesn't, he's actually quite pro-choice, but Roe versus Wade seems kind of made up, and my brother clerked for Harry Blackman. Okay, so it's worse because they say they're originalists and then they pull this. That's what makes it maybe worse. So I feel like if we were Tony Soprano or something, they call it 2. But in Godfather 2, when Michael says to Fredo, "You broke my heart," okay, no, they broke my heart with that case. They really did, because I want them to succeed. I really do, all of them. And so I thought it was horrible, and that's what I said on MSNBC. You can read in the Atlantic. They made the Constitution itself unconstitutional because they put themselves their own. Now, final point. It's not preposterous to actually, if you were drafting a Constitution, to draft a Constitution in which ex-presidents are utterly immune from criminal prosecution. And here's the argument. If I were drafting a Constitution for other countries, I might be open to this. In a country in Africa or in Asia, we're a fledgling democracy. We're just trying to make this thing work. Here's what we're worried about. We're worried about people not willing to leave power, when they've, and if actually, when they leave power, they're not only going to abandon their office, but they're going to go to prison, and their families are going to go to prison. They will fight to the death. They won't leave. And so you could imagine, and the ultimate irony is going to be, if she loses and he wins, this is going to limit his ability to go after Biden and all the rest. So history can be ironic in that way. But that's not what seemed to motivate them. It seemed to motivate them was a certain, because if you just look at the lineup, the people who did this are people appointed by Trump or who are looking the other way about Trump, and that was so. If you were just coming up with sensible rules, I could understand a constitution that created absolute immunity for ex-presidents so that they will leave. But that's just not our Constitution. George Washington never insisted on anything like that, and it was designed by him for him. So that was a long answer, but I hope it was a fair and honest one to a great question. Thank you.
Professor James Stoner has a theory of common law originalism where he argues that in order to understand the political process of the Constitution, you need to read it in the Anglo-American and English common law tradition, especially for legislative and executive power. To what extent do you think that is a valid theory of originalism, and how would you critique it?
I don't know a lot about it. It seems pretty important and helpful to think about the common law background. They use lots of common law phrases: habeas corpus, bills of attainder, corruption of the blood, ex post facto laws. So that seems sensible to me. I'm going to lose half of you, but at least I'm honest. I'll be brutally honest. Life is short, so you have to start with the best. They're my books, not Jim Stoner's. Just are. That's why. No, because you guys, everyone is not an expert on Twitter, even though they think they are. And it's so easy in 3 minutes to figure out who's good. You look at the Yelp reviews, you look at J.D. Power and Associates, you actually, look and see, what the rankings are, okay? There's a reason that, I'll get a laugh line here. You're not at GW, okay? I got a laugh there, and I'm doing GW tomorrow, okay? You're not at American, okay? And now I'm going to really lose you, but, if Yale had said yes, most of you would have gone to Yale. There's actually, I'm honest, there's a pecking order, okay? And two things that are opposed in law can't both be right. They could both be wrong. One of them could be right, but for the wrong reason. So I'm telling my friend Brad, in the podcast, well, Frankfurter and Black on certain issues can't both be right because they're opposed on incorporation or what have you. So life is short, okay? Start with the 8 Akhil Amar books because he actually is a sterling professor at Yale and he was hired at the age of 26 and he is more cited by the United States Supreme Court across the board, and he's not a partisan hack because the liberals and the conservatives both cite him. I'm ridiculously proud of these books. So when they said come, I said, don't give me any money, have National FedSoc give the books out, and you got to read the books. You got to listen to the podcast. They will make you smarter. But Jim Stoner, I believe, is he a political scientist? And I don't know him so well.
I believe he is a political scientist.
So I actually spent 3 years in law school. Okay? So I'm telling you, life is short. If you want to ask me about Adrian Vermeule, I'll talk about my friend Adrian Vermeule. If you want to ask me about my friend Randy Barnett, I'll talk about my friend Randy Barnett. But honestly, if it's a pretty good and important thing, I probably said it first. I did. I mean, that's actually true. I've written 8 damn books. And they're big, fat, and you got to read them. And so after you've read those, you can read what Jim Stoner has to say. I'm being, because life is short. And start with the most serious stuff. Because I told you, it's a whole thing. And if Jim Stoner has written about every provision of the Constitution, that's news to me, because I actually have. Almost every provision of the Constitution, every article, I've actually said something interesting and important. So pick an article, any article, pick a card, and I'll actually tell you, my theory of it, and that's then, frankly, the thing to beat. What does someone else say that's different, and you can then compare it. That seems sensible to me, to read the Constitution, understanding that these are people trained in English common law. That seems sensible.
On the topic of presidential immunity, are there any limits as to the scope of the exercise of executive power that Congress can criminalize? And
yes, there are. So, and listen to the episode. If Congress tried to make it a crime to issue a good faith pardon, to veto a bill in good faith, on Youngstown-like grounds, and we could talk now about John Roberts' he clerked for 2. Okay, he clerked for Henry Friendly, who clerked for Brandeis, but he also clerked for William Rehnquist, who clerked for Robert Jackson. And so Youngstown gives you a framework for analyzing what sorts of things can't be done, even with a statute. Now, Congress hasn't typically passed statutes like that, and the reason it typically hasn't is you need a president to sign that statute, That's Constitution Rock 101. I'm just a bill sitting on Capitol Hill, okay, and I need to get the signature of the president. How many of you have seen, I know I'm dating myself, but is it great? Okay, so take a look. This is Chada. This is Con Law 101. So what would it say that a president actually signed? Now, if it passed over his veto, that would be actually reach out of footnote 13, because it's important whether certain things the presidents have acquiesced or objected to certain limits on their power. But of course, Congress can't make it a crime to veto a bill or to pardon someone. Yeah, of course there are limits.
Of the big Supreme Court cases the last term, Trump v. Anderson was also a good one.
Yes, a bad one.
I was wondering what your thoughts are on what the Supreme Court did in that case.
Yeah, that was embarrassing. I wrote a brief. Read the brief. 9 justice, at least it wasn't partisan because they were all so stupid. I'm so disheartened by that because Section 3 of the 14th Amendment actually says something, and they don't know any of that. I actually wrote about Section 3 20 years ago, and anyone else, you ask them if they had actually written something about this before January 6th. You should give them more credit if they have, because they're writing it behind a veil of ignorance, applying to both parties. So, Supreme Court, we have a civil war, and more than 500,000 people die, and Lincoln is assassinated, and in the wake of that, we have these amendments, people died for them, and the Supreme Court has been horrible on every one. It actually says that, and first sentence is overruling stupid Supreme Court case that just made stuff up. Dred Scott, which Lincoln says is an astonisher in legal history, but Section 1 says racial equality, and the court gives you Plessy versus Ferguson. Okay? And it also says fundamental rights, privileges, and means of citizenship, and the court reads that out of the Constitution. In the slaughterhouse cases, it takes a long time before we do incorporation of the Bill of Rights, which was core 14th Amendment. So they spit on Section 1. And then, actually, Section 2 to this day hasn't been conventionally enforced. It's about saying if there's disfranchisement, there will be an apportionment penalty to pay in the House and Electoral College. And after the end of Reconstruction in the 1880s and 1890s, all blacks, 95% of blacks were disfranchised in much of the former Confederacy. I'm looking at Brad because he's got books on his shelf all about this, and the courts did nothing. And the great Oliver Wendell Holmes and Giles versus Harris says, what do you want us to do about it? And this is why I hate Holmes. He's got several pictures of him, but I don't, because Holmes actually is not enforcing Section 2 of the 14th Amendment. He said, what do you want us to do about it? Okay? This is spitting at Section 3. Section 5, that's City of Bernie. They're trying to give broad power to Congress, and the court actually doesn't get, because, I love Anthony Kennedy. He's on my speed dial. We actually are genuine friends, but he doesn't know the history. He doesn't know that, so again and again and again, they're not taking seriously the 14th Amendment, and they're the wise men in Washington, D.C. who know shit, okay? So if you're an originalist, that's not what you need to know. You need to know the Constitution, the history behind it. You need to know my books, okay? Because I will actually tell you what Section 1, 2, 3, 4, and 5 are about, and ideally I'm going to say it before there's a debate about this president or that one. So they couldn't believe that Section 3 said what it meant, but here's what it meant. If you take an oath to the Constitution, and you betray that oath and support an insurrection against the government, you shouldn't be trusted with power again. And they know, and that does limit voters' choices. It does. So does the 35-year-old clause. And we could go back to ancient Rome, and I could tell you why they said 35 and what that was all about. Okay? It was about dynasty in an interesting way. But if you don't know why they did things, you say, well, it limits the voters' choice. Voters should be able to choose on election day. They saw that democracy was at issue on both sides. Because, limiting people's choices, not letting them pick officers is not so good, but putting insurrectionists back in power after they tried to destroy the government, that's not so good either. Okay? They saw it with distinctive clarity, and if you're an originalist, you're going to pay attention to what we, the people, actually did when they focused on an issue clearly. Just like, they saw with distinctive clarity, okay, do we want to immunize ex-presidents for their criminal misconduct in office or not? You could make an argument either way, but they actually made a choice. And originalism is taking seriously what they actually said. So Trump versus Anderson was actually a disgrace. I got my ass kicked 9-0, and I don't usually get my ass kicked 9-0, but that's because they didn't read the brief with any care, and I filed an amicus brief, and please take a look at it. I'm ridiculously proud of this amicus brief. It's really good. And it has lots of evidence in it, and it's not partisan. Will Vogt agrees with me, and he's a Bator Prize winner, as am I. And Mike Paulson agrees with me, and Will was my TA, and then he's John Roberts' favorite law clerk, and Mike Paulson was my roommate, and they're conservatives, okay? And read their scholarship on this. They have a forthcoming piece in the Harvard Law Review. Will is heartbroken, actually, about what John Roberts, did in Trump versus Anderson. So history will judge us all. Okay? Dred Scott has not aged well because they just disregard what the Constitution really said.